Hello, I am Aditya Gupta and I am a lawyer at the Delhi High Court. Today we will be studying the module of copyright infringement. By the end of this module, I hope you will understand the different rights available to an owner of a copyright, the tests for infringement of copyright, as well as how each of these rights are available for the different kinds of works. Let's begin. First, a bit of a recap. As you have studied in earlier modules, there are different kinds of works which are protected by copyright. The relevant section here is section 13 of the Copyright Act, which provides that copyright shall be available to literary works, dramatic works, musical works, artistic works, sound recordings, and cinematograph films. Therefore, it is important to note that each of these works are entitled to different kinds of rights, and these are the rights that we will study today. First, let's move on to the meaning of copyright. For the meaning of copyright, you need to study section 14 of the Copyright Act. Section 14 defines copyright and says that copyright is the exclusive right to do or the exclusive right to authorize someone else to do several acts. Copyright essentially is a bundle of exclusive rights, and in a broad sense they can be categorized as follows. First, the right of reproduction. Second, the right to issue copies. Third, the right to public performance and communication. Fourth, the right of adaptation and translation or modification. And lastly, the right of sale or rental. We will study each of these rights, some in more detail and some, as you can see, are pretty self-evident, and thus we will not go into as much detail for some of these rights. First, let's see the right of reproduction. This is the exclusive right to make a copy of a copyrighted work. As you could probably imagine, this is the heart of copyright law, the right to copy the work. In order to prove that the right of reproduction has been infringed, the plaintiff must prove two things. First, the defendant copied the plaintiff's work as opposed to creating it independently, and two, that is, there is substantial similarity between the plaintiff's works and the defendant's work. Let's see the first requirement first. The first requirement is that the defendant must have copied the plaintiff's work, and thus it must be a case of copying as opposed to independent creation. Independent creation is a complete defense in copyright law. Independent creation means that the defendant or the alleged infringer came up with the allegedly infringing work without having any reference to the plaintiff's work, or even without knowing of the plaintiff's work. There are several ways through which a plaintiff can try and prove that the defendant has copied the plaintiff's work as opposed to creating it independently. One way is a very direct way, which is about mechanical copying. For instance, if the defendant makes copies of the CDs containing the plaintiff's work, then clearly it is a case of copying as opposed to independent creation. But not all cases are so simple. There may be cases where it is difficult to know whether the defendant has actually copied it or created the work independently. There are sometimes direct evidences of copying. Sometimes the defendant might even admit that it copied the plaintiff's work and solely limit its defense to the second prong of the infringement test, that is, the defendant's work is not substantially similar to the plaintiff's work. An interesting case in which the defendant admitted to have copied the plaintiff's work was Roger versus Coons in the United States, wherein the defendant admitted that it had seen the plaintiff's work and then had instructed his artisans to copy it. His defense in that case solely related to substantial similarity and the doctrine of fair use, which you have studied in another module. Let's move back to the ways in which a plaintiff can prove that the defendant has copied his work. One, as I mentioned, is the direct evidence of copying. The more common way of proving that the defendant has copied the plaintiff's work is by combining two different tests. First, the plaintiff must show the defendant had access to the plaintiff's work, and apart from the access, the plaintiff needs to also show that there is probative similarity between the plaintiff's work and the defendant's work. By showing access to the plaintiff's work, the plaintiff shows that an inference can be made that the defendant must have copied the plaintiff's work. Thus, the plaintiff needs to show that the defendant either had direct access, or by virtue of the fact that the plaintiff's work was so widely disseminated, it can be presumed that the defendant has access to the work. For instance, the plaintiff may have handed the work directly to the defendant. This is clearly a case of access. Or it might be a case where the plaintiff's books or movies were widely published and were available in many bookstores or movie stores. In this case, it can be presumed that the defendant had access to the plaintiff's work. But access by itself is not enough to prove copying. The plaintiff must also show that there is probative evidence of similarity between the two works. The plaintiff must show that the similarity is such that the court can reach an inference that the defendant copied the plaintiff's work. It is also important to note that the higher the degree of similarity, the more likely it is that the court will infer access. That is, in cases where the plaintiff is finding it difficult to prove that the defendant had access to the plaintiff's work, if the plaintiff can show that the defendant's work was very similar to the plaintiff's work, then in that case the court might even infer that the only logical conclusion is that the defendant must have had access to the plaintiff's work and has copied it. A very important way on which certain plaintiffs rely to prove access and copying is that the defendant has even copied the errors in the plaintiff's work. For instance, the plaintiff has made some grammatical mistakes in his work, and the defendant copies even these grammatical mistakes, then it is quite clear that the defendant must have copied it and did not apply his own mind and did not create the work independently. The second part of the test relating to infringement of copyright is improper appropriation. That is, the part of the plaintiff's work that the defendant copied must amount to improper appropriation. What does this mean? That is, if the defendant copied certain unprotected elements of the plaintiff's work, it does not amount to copyright infringement. As you can imagine, almost every copyrighted work has some protectable elements and some unprotectable elements. The examples of unprotectable elements are ideas. In an earlier module, you have studied the idea-expression dichotomy, which says that only the expression in a copyrighted work is protectable but not the underlying idea. Let's say the defendant copies the idea of the plaintiff's work but not its expression. Can it be said that the defendant has infringed the plaintiff's work? The clear answer is no. For the copying to reach the level of improper appropriation, only the protected elements of the plaintiff's work will be considered and the unprotected elements will not be considered. Similarly, there are certain scenes which are considered as senza faire. For instance, there are certain elements which are stock of the trade, and every person, every creator of any work is entitled to use them, and even if the defendant has copied such senza faire from the plaintiff's work, it cannot be considered to be copyright infringement. A landmark case relating to the tests of infringement of copyright is R.G. Anand versus Deluxe Films. This is a case from the Supreme Court which lays down the test of substantial similarity, and it is worth reading the case and I highly recommend it. It is important for us to go over the test as called out by the Supreme Court, and I will deal with each one by one. Firstly, where the same idea is being developed in a different manner, it is manifest that the source being common, similarities are bound to occur. In such a case, the court should determine whether or not the similarities are on the fundamental or the substantial aspects of the mode of expression adopted in the copyrighted work. What the Supreme Court is really trying to say that when people are copying from a common source, it is bound to happen that they will copy the same ideas. What the courts have to really look at is whether the defendant has copied the plaintiff's expression. This is clearly an extension of the idea-expression dichotomy, wherein only the expression of a copyrighted work is protected but not the underlying idea. Secondly, if the defendant's work is nothing but a literal imitation of the copyrighted work with some variations here and there, it would amount to a violation of copyright. In other words, in order to be actionable, the copy must be substantial and a material one, which at once leads to the conclusion that defendant is guilty of an act of piracy. What this means is that the defendant cannot get away by making small variation in the plaintiff's work, but it is also important to know that the copying must be substantial and material. We will discuss the de minimis test subsequently, which is relevant for this point. Thirdly, and this is very important, the Supreme Court says that one of the surest and the safest tests to determine whether or not there has been a violation of copyright is to see if the reader, spectator or the viewer, after having read or seen both the works, is clearly of the opinion and gets an unmistakable impression that the subsequent work appears to be a copy of the original. Therefore, it seems that the Supreme Court wants a viewer or a spectator to see both the works and then from his point of view whether he would consider them to be copies of each other. Some courts have said that this looks like a common man test or a look and feel test, whether the look and feel of both the works to a common man appears to be the same. Let's go to the next point. However, apart from the similarities appearing in the two works, there are also material and broad dissimilarities which negative the intention to copy the original, and the coincidences appearing in the two works are clearly incidental. No infringement of copyright comes into existence. It is important to read both these parts of this sentence conjunctively. The court says that there must be material and broad dissimilarity between the two works, which would negative any intention to copy the work, and secondly, any similarities must only be incidental. Therefore, if the defendant adds a lot of material to the plaintiff's work and there are material and broad dissimilarities between the two works, it may be considered not to be copyright infringement if the second condition is also satisfied, that is, the coincidences in the two works or the similarities in the two works must only be incidental. Lastly, the Supreme Court held that the violation of copyright amounts to an act of piracy. It must be proved by clear and cogent evidence. Therefore, the court said that the standard of proof to prove copyright infringement seems to be a high one.